so that it does not look that there is discrimination. And there are two parallel laws for the mighty and for the constables. Your Honor, a mere statement that the police have a blue code of silence is not factual. It is a statement made to hoodwink the court. The applicant, IPOA, is seeking 21 days to detain the respondent in a police station, not manned by IPOA staff, manned by the same police officers. At one hand, IPOA is confident with the police that remand him in police station. In the other hand, it is telling you, Your Honor, the police have a blue code of silence. You can't speak from both sides. Your Honor, this country, as citizens of this country, every government entity operates within its mandate. We urge the court to find that there are no compelling reasons. Your Honor, the Judiciary Handbook on Bail and Bond, which the court is very aware, has provided for parameters to be considered for denial for bail. None has been presented before you. The applicant says there is a public uproar. There are demonstrations on the streets. This matter has gone to the Senate. It has gone to the National Assembly. And the Commander-in-Chief of the Armed Forces, His Excellency, President Dr. William Ruto, has talked about it. It is our submissions that out of that, this is a knee-jerk reaction to show everybody and the people are talking that we have arrested somebody. Your Honor, may you get favor in my submissions and allow the advocates with me to deal with the law and the authorities that will be supplying to court. I hope the state has been given those authorities. Thank you.
Right. Anybody else again?
Yes, Your Honor.
What's the name?
Stanley Kinyanjui.
Kinyanjui, yes.
Yes, Your Honor. Yes, and Your Honor, I associate myself with the submissions of my senior, Mr. Danstan Omari. And I begin by saying, Your Honor, that there can never be public interest greater than a constitutional value. That being said, Your Honor, the application for bail is grounded on two principal instruments. Which is one, the Constitution of Kenya, and two, the bail and bond policy guidelines. Now, Your Honor will note that these two principal instruments then give birth to two foundational values upon which the application for bail has been made today. The first foundational value, Your Honor, is the presumption of innocence. And the second, Your Honor, is the fundamental right to liberty. And paragraph 3.1 of the bail and policy guidelines offer an explanation as to the second value, and goes on to tell us that pretrial detention, such as the one that this court is being invited to make, should be the last resort. And the criminal justice institutions, which is this honorable court, should make every reasonable attempt to avoid subjecting a suspect to pretrial detention. Your Honor, having laid those values, then we must remind ourselves that the bail and bond policy guidelines are guided by principles derived from international instruments. Instruments and practices, Your Honor. And I say that, noting that there is nowhere that politics of the day inform bail and bond policy guidelines. And one such instrument, Your Honor, footnoted at footnote number 20, is the African Union draft guidelines on the use and conditions of police custody and pretrial detention in Africa discussion document of February 2013. And then Your Honor will note that at that time, these guidelines were not yet adopted, but were later adopted in what became to be known as the Luanda Guidelines of 2014. And Your Honor, those guidelines identify three questions leading to a determination of an order of pre-trial detention, whether in the negative or the positive. And one cannot help, Your Honor, but notice the correlation between those three fundamental questions with the fundamental values as earlier on stated. And one captured that paragraph 10b of those regulations is the same value, or rather the question of which is the last resort. As my senior has submitted, that this court has the power to give orders and restrictive orders as such to the respondent in this matter, from appearing or being seen anywhere near the scene of crime. The second question this court should answer, is whether there are grounds which have been clearly established in law and not motivated by discrimination of any kind. That is paragraph 11 of the Luanda Guidelines. And Your Honor, in this case, I need to stress on the word discrimination. My colleague will submit on the case of Betty Jemutai. And Your Honor will note that the only reason being advanced by the applicants in this case is the fact that the respondent is a police officer. Your Honor, if that is not discrimination, what is? And third, that is the last question this court should consider, are there any reasonable grounds to believe that the suspect has been involved in an offense carrying a custodial sentence, and Your Honor, I stress on the word and, being conjunctively, there is a danger to abscond, commit further serious offenses, or if released, the individual will not be in the interest of justice. Your Honor has had the benefit of hearing the evidence and the testimony of the deponent of the affidavit. Your Honor, there is no tangible evidence that has been submitted before this court other than the mere apprehension that the respondent is likely to interfere with investigations. Your Honor, the deponent has gone on further to remind us, and he does so in his affidavit and the application, there are already preliminary investigations which have realized some certain facts. Those facts are not within the court's knowledge. And there's not even a single attempt to inform us why, in the application of denying someone liberty, the information gathered is not before this honorable court. Your Honor, those are my humble submissions insofar as the application for bail is concerned.
Okay.
And before, Your Honor, I sit down, I need to further point out to this honorable court that the application Your Honor, if you look at prayer number 2 of that application, which is the substantive prayer, asks that this court, that the respondent be detained at Capitol Hill Police Station or any other police station within the Republic of Kenya as the investigations may dictate for a period of 21 working days. Your Honor, one can, if you are not keen enough, one will miss the mischief in that prayer. And the mischief is in the wording of 21 working days. Your Honor, will note that this application has been brought under the ambits of Section 36A of the Criminal Procedure Code, which is a written statute. And as we all know, as lawyers and even students of the law in this courtroom, that statutes have their own ways of interpretation.
Yes.
And, Your Honor, to discourage this sort of mischief, the Parliament, in its own wisdom, brought into force the Interpretation of General Provisions Act. And, Your Honor, Section 57D
Serial number?
Section 57D.
Okay.
It states that where an act or proceeding is directed or allowed to be done or taken within any time not exceeding 6 days, excluded days shall not be reckoned in the computation of time. The excluded days are Sundays and public holidays. That is if the prayer or any request is made where computation of time is required for less than 6 days. You're not they're asking for 21 working days. That is well over the 6 days which are provided. And Your Honor will note that this question was addressed in the case of Longinus Oroni Murunga versus David Masika Matumbo, Civil Appeal number 319 of 2013, in the Court of Appeal at Eldoret. And Your Honor, paragraph 12 of that decision goes on to explain, so that for the benefit of the applicant, they do not perhaps wish to proceed with this mistake in another case, that the section 57D is very clear. And in fact, it goes in tandem with Article 259(6) of the Constitution in terms of computation of time. Therefore, it is my submission that the application as framed, we are all aware that we are bound by our pleadings. that the orders cannot be granted. As such, the application is incompetent and the respondent should be released forthwith. That's all, Your Honor.
All right.
Your Honor, may I?
Oh, you want to say something?
Yes, and let me say something. I'll
Can
be very
you remind me your name?
Yes, Ms. Sophie Nekesa, Your Honor.
Okay.
I will be very brief, Your Honor. I want to deal with the applicant's reasons for detention.
Okay.
As defined from paragraphs 31, from paragraphs 24 up to paragraph 31. Your Honor, those are the reasons the applicant has put forth to this court as for the reasons for the need to detain the respondent herein. Your Honor, my submission is that all those reasons listed from paragraph 24 to paragraph 31, for all those reasons that they have listed, they do not need the respondent for that. Your Honor, this matter, or rather my submissions, are based on the authority which I have served the DPP, Betty Jemtai. This is a miscellaneous criminal application. Betty Jemtai Kimeyo versus the Republic. This is a miscellaneous criminal application number 26 of 2018. Your Honor, there are three things, or rather three important action points that I wish to address from this authority.
Yes.
Miscellaneous criminal application number 26 of 2018. Betty Jemtai here. Yes. So, Your Honor, paragraph 7 of that authority, the court is saying the respondent can be detained based on the available evidence. Available evidence are the wordings of that paragraph, Your Honor. It has already been shown from the supporting affidavit of the applicant. No evidence has been shown to this court, and therefore they are mere averments. It has not been shown, Your Honor, paragraph 9 of that authority, the reason as to why the respondent might be detained further. The prosecution needs to show that the suspect is a flight risk or is likely to escape or is likely to interfere with the witnesses. Your Honor, even from the supporting affidavit of the applicant, they have not averred to that effect. There is nowhere the applicant is saying the respondent is a flight risk or is likely to escape. And number one reason why the respondent is not a flight risk, why he is not likely to escape, and why they did not put that in their supporting affidavit is because the respondent is a serving police officer, Your Honor. He cannot escape and leave his job. That is what he does for a living. That is what sustains him and his family. There are averments to the effect that the respondent might interfere with witnesses. Your Honor, paragraph 3 of the supporting affidavit of the applicant. The applicant says they have already interrogated some witnesses. So when at paragraph 30 they say they will already interfere with witnesses, we are wondering if who are these witnesses that are yet to be interrogated? Because at one point they will interfere with the witnesses, at another point we have interrogated the witnesses. So where is the truth? If anything, Your Honor, this is a police corporal. Constable, apologies, Your Honor, is a police constable. It cannot be true when the applicant says he is a police officer. That is paragraph 32 of the supporting affidavit. It cannot be said that the police officer wields police powers. A police constable, Your Honor, is not capable of wielding any police powers in the context of these investigations. So, Your Honor, if we read the supporting affidavit from paragraph 15 all the way to paragraph 22, Your Honor, the applicant is saying the respondent is likely to. There is a likelihood the respondent will. There is a likelihood the respondent did. Your Honor, that just goes on to show that there is no evidence. Like my senior put it, they are mere apprehensions. There is no any evidence whatsoever that has been brought to this court to support their arguments, and therefore they are mere statements which cannot be proved. So the conclusion of that authority, that is paragraph 14, and this is the action of this authority, Your Honor. I do not find that the police offer good reasons for the continued detention of the arrested person, because the matters they use to justify the detention, taking witness statements, obtaining call data, securing forensic reports, those are things that can be accomplished by the applicant without the physical need for the respondent. And that is why, Your Honor, we are asking that the application be disallowed, because the respondent is not physically needed for the applicant to carry out his duties. Now, Your Honor, there is a test that was established in the celebrated case of Oscar Sudi that my senior briefly touched on. This is Sudi Oscar Kipchumba versus the Republic. It's a criminal revision number 208 of 2020. Your Honor, in this case, there's established a double test that must be passed by the applicant for them to be able to detain the respondent. And these are the two tests, Your Honor. Number one is that there must exist exceptional circumstances. Exceptional circumstances for the applicant to want to detain the respondent. Your Honor, you have been told there are other people that are yet to be arrested. There is suspicion that other people were involved. From the deponent's own arguments, when he was here, he said some of the people are policemen and some are not policemen. If there are people who are involved together with the respondent, Your Honor, and they are not here, we do not know the extent of their involvement in this matter. So why would it be that the detention of the respondent is exceptional? Our submission on that, Your Honor, is that it is not an exceptional circumstance to want to detain the respondent. Number two, Your Honor, the second limb of the double test is the need for the applicant to use the least restrictive means. Least restrictive means. Your Honor, detention of the respondents cannot be said to be the least restrictive means for the applicant to be able to conclude their investigations. These courts can release the respondents on reasonable cash or bond terms and impose conditions that will enable him to attend the court. This court can impose a condition that the respondent should not leave the court's jurisdiction, that the respondent will be able to respond to the IO or any investigator whenever he is called upon. It cannot be said that the only way for the investigations to be carried out is detention of the respondents. Your Honor, those are my brief submissions on the matter, and for that reason, we pray that the application be disallowed, the application by the applicant be disallowed, and the respondent be released on reasonable bond terms or cash bail terms. Thank you, Your Honor.
Your Honor, one word before, because we'll not have time to do any submission. I apologize. My client tells me he had told me to pass his sincere condolences to the family of the loss of the deceased. He's a human being, and any family that has lost anybody is a big disaster to that family. And on behalf of his defense team, we also pass our condolences to the bereaved family, and may God give them grace as they deal with this sudden death. That's all, Your Honor.
Okay. Prosecutor, do you have something to say in response to what
Yes, may it please Your Honor, my name is Okundo.
Yeah.
Your Honor, so we are both the applicant and the respondent at the same time, so I'll take it globally in my response.
You are here for the state?
Yes.
IPOA.
Yes.
Okay.
For the state.
Okay. Proceed.
I'm a prosecutor.
Okay.
Your Honor, we humbly submit that the evidence which has been tabled before you in the form of a affidavit clearly lays bare the reasons as to why the respondent should be detained for the period that has been requested. The circumstances leading to the investigation by IPOA is not in dispute. And this has been categorically stated in the affidavit. There is no dispute that life was lost. There is no dispute that the deceased died in a police cell at Central Police Station, to be specific. And this was confirmed by the medical report which has been attached to the affidavit. And the OB extract which have been attached, which clearly demonstrate that the deceased was removed from the police cell, taken to Bangapi Hospital, where he was proved to be dead. There is no intervening incident. There is nothing which intervened which could say that the deceased did not die out of the cell. That is clearly demonstrated. It has also been demonstrated in the affidavit that the respondent is the one who was manned the scent at the time. There was no any other person. That has not even been disputed. And the key reasons, which are the key grounds why this application has been made, is that there is fear of interference with witnesses. And the reasons have been given in the affidavit, which clearly demonstrate that this officer, the respondent, is likely to interfere with witnesses whose statements are necessary and who are police officers. Your Honor, it's our humble submission that when it comes to the issue of rank, that's not what counts when it comes to interference with witnesses. Interference can take any form, any shape. You don't have to have influence or bear any influence. Your Honor, it has also been submitted before you. It has also been laid bare in the affidavit that the nature of the investigations are complex. And, Your Honor, this court, and it has been decided in several cases, when the courts can consider granting such application. And these, I'll enumerate them. We'll give authorities, I'll give the citation. One is the serious nature of the offense, which is under investigation. The second ground is early and sensitive stage of investigations. The third issue is the forensic and surveillance-based complexity of the case. And finally, risk of interference with ongoing inquiries. The facts which have been deposed in the affidavit clearly demonstrate the four grounds which I've stated. Your Honor, it has been submitted that the arrest of the respondent was a knee-jerk reaction. We submit it was not. It has been established as to when investigation in this matter began by IPOL. It did not begin yesterday. It did not begin with the arrest of the respondent. Your Honor, at this stage, we are dealing with Article 49 of the Constitution and not Article 50. What Article 49 expects of the applicant in such a case is just to lay bare before the court the justification for continued detention of a suspect. We are not talking about the rights of an accused person who has already been arraigned before the court, so as to apply the principles which are contained in the bail and bonds, the guidelines which have been given. Your Honor, there are compelling reasons. Have the respondent detained to avoid interference with the investigation. Indeed, it is demonstrated in the affidavit that there was an attempt from the beginning when it was realized that the theory of the suicide failed and it was established that the deceased was killed in a police cell. There was an attempt at interference or derailing the investigation from the beginning. And this has been demonstrated with attempts to destroy the data in the CCTVs. That is demonstrated, and it's not in. A person who from the beginning wants to destroy the evidence, that is a person who will go all the way to interfere with any kind of incriminating evidence which may be unearthed by the investigation. And this is not just a mere preemption. There is all the likelihood. Your Honor, it has been stated that there are other suspects who are, include even police officers, who are likely to be arrested. They are out there. There are people who are known to the respondent. It has been decided in the case which we cite that where a suspect is likely to be out and communicate with witnesses and even other suspects who are still on the run, he should be denied, he should be detained when investigations are ongoing. You know, the investigation in this matter is still at very early stage. And it has been demonstrated how sensitive this matter is. Your Honor, we submit that there has been an attempt. It has been demonstrated that the investigating officers have been finding it difficult to retrieve information from the police officers. Requiring more reason why the suspect who is in custody should remain in custody for a few days, which has been requested. Your Honor, I want to respond to the authority which you were given. This is miscellaneous criminal application number 26 of 2018. This one of Betty Jemtai, female applicant, versus public. At the onset, Your Honor, I wish to submit that this was an application dealing with the extension of time after an applicant has been detained. It does not apply to this instant case. Now, we submit that there are justifiable reasons for continued detention of the respondent before the court. Article 24 of the Constitution allows for limitation of freedom. Regard only need to be given to the importance of that limitation. The importance of the limitation which we are seeking is to enable investigation to be completed without interference. It will be total injustice, travesty justice, if investigation were interfered with. At the end of the day, there are no witnesses, there's no tangible evidence to be presented before the court because a suspect interfered with the investigation. It will be a disservice, in fact a dishonorable thing, to the family who was lost. It goes even a long way in protecting victims of crime. Which this court has a duty to do. Your Honor, we finally submit that the investigation here has been established to involve issues of forensic and surveillance. And part of it has been demonstrated in the affidavit that it takes a process of trying to retrieve data which has been attempted to interfere. And it has been stated by the investigating officer on oath that this is something beyond him. It's done by an expert outside within his control. He may not have control over that. And the days which have been sought, Your Honor, are reasonable in the circumstances. We are not saying that the applicant, the respondent, will not be given a fair hearing. Once the investigation is complete, it is charged. He'll have his fair hearing, have his day in court without the rights of an accused person. We are just protecting the evidence to be tendered. You know, on the authority which you have given on the issue of calculation of this, you know, we submit that there is no mischief in the application which you have made. In any case, that does not go to the root of the application, even if you are to apply the rule of computation of this. These are mere procedural issues and does not touch on the tangible aspect of the importance of carrying out investigation and requiring this. "21 working days requested." It's not a mystery. It's an estimation in the sight of an investigating officer. And this, to the investigating officer, could be just a matter of nomenclature. He could maybe, to him, he would have asked for 30 days. But this is workable, it's granted, Your Honor. We urge you to allow them. our application for detention for 21 days and reject the application for bond at this time, as we jeopardize the investigation in this case.
All right. Anybody else again? In the prospective right?
If I may,
Yes.
my name is Kinoti from IPOA. My Lord, let me first say we agree entirely with the submissions made by the Learned Counsel.
A point of objection. I don't know under which provision an investigator will address you, because the investigators in this matter are IPOA. The officer who deponed the affidavit has given his side of the story. IPOA cannot submit. It is a preserve of the DPP. IPOA is a witness that we have cross-examined. And therefore, if IPOA has anything to say, let it hand over that to the DPP. The DPP should not cede ground to this crucial matter. IPOA cannot prosecute, it can only investigate. Article 157 mandates the DPP to be the mouthpiece of IPOA. So, Your Honor, we object to IPOA being allowed to address the court.
This one I need a response from Nora. We have given up to your driving.
No, we haven't. Yola. I thought our submissions were ably given by Mr. Mpundo. Yes, but I think I'll be honest. I do not know what the officer from my power wanted to submit on.
Now, what we're saying is, if they are investigators, then they should also come through you.
That is clear in Article 157.
Yes.
Much
Mr. Kinoti,
Your Honor, if I may.
I'm not recording that meanwhile. I'm just saying, we have something we should have also passed over to the DPP of Stock. What's your take?
That is fine, Your Honor, and indeed we are working closely with the DPP. But, Your Honor, for purposes of record and the law, the participation of IPOA in bail proceedings has been determined by the High Court that IPOA can participate and address the court in the case of Republic versus Frederick Oleleliman, where IPOA was granted audience by the High Court in a decision, Your Honor, of the High Court in this case. We also didn't submit your decisions. So, Your Honor, the participation of IPOA in addressing the court is a matter that the High Court has settled. Yes, Your Honor. And so, Your Honor, there is no prejudice whatsoever on IPOA submitting on this issue. And in fact, Your Honor, as an officer of the court, all I wanted to do was bring to the court attention that decision that I've just mentioned of Republic versus Frederick Oleleliman, which is at complete at one with current case that Your Honor is dealing with. And having brought it to your attention, Your Honor, that decision is available at EKLR. When you retire, Your Honor, I would urge you to have a look at that decision.
So, I hear you to say you are investigating the murder issue, is it not? So basically, you are for the victim.
Yes, Your Honor.
Is that so?
Yes, Your Honor.
What about the Supreme Court case of Redrick Waso?
Your Honor, before you go there,
Just doesn't. Yeah, because it gives you some attitude, to what extent that the counsel for the victim should address the court. Is it not?
It does, Your Honor. It does.
To what extent the Redrick Waso case, the Supreme Court?
Yes, Your Honor, it does. And in
And I
fact,
believe the Supreme Court case finds the courts below.
it does, Your Honor.
So I was thinking that you can also look at it and see.
you know what I was raising?
Yes.
IPOA does not have jurisdiction under the Victims Act. They are investigators, like EACC, like the DCI, like KRA, they do not represent the victim. And therefore they cannot pretend to be investigators and represent watching brief. That role is very clear, and that notion should be put to settle. The DPP is the only one under 157 with that constitutional mandate. Anybody else, if they are civil society groups representing the family, they have a right. Waswa's case has given them the right and the scope to participate. But an investigator talks through the DPP. He cannot pretend to be a prosecutor. That's all that we are saying. Their roles and the mandate is very clear. Section 3 of IPOA is very clear, very distinct from Article 157. Let us defend the constitutionality of this country.
Okay, I hear you, Mr. Mari, that's enough.
That's all.
So, just a minute, Mr. Kinoti, are you okay that you can pass your submissions to Mr. Opondo?
We will pass our submissions to Mr. Opondo. We have no objection to passing our submissions to Mr. Opondo.
Okay.
But Your Honor, for purposes of record, the position of the law enunciated by Learned Counsel Mr. Omari is not correct, Your Honor, for purposes of record.
Okay.
Our position, Your Honor, our position remains that as decided by the court in that case, just mentioned, IPOA can participate in proceedings before the court. Your Honor, we have no objection of passing our whatever we need to.
For the victim,
if the court issues
they're allowed to participate, that one is allowed.
I think also what is happening is that my colleague is misreading that decision. Because if you look at that decision, and I believe that is the position, is that IPOA at that time was watching brief.
Yes.
Okay.
In this case, even if you look at the heading of this proceedings, it is Republic to the IPOA.
Okay.
So your mouthpiece is the DPP.
I think as the DPP, let's put that matter to rest.
Yes.
We will advise accordingly.
Yes.
We will respond to the issues raised. Yes, on behalf of IPOA.
I think that is settled.
Yes.
That's it.
Mr. Kinoti?
Yes, Your Honor. We are okay proceeding with through the DPP, but the position of the law, Your Honor, is that we have
Opondo,
stated.
you had said something?
Yes, Your Honor. I said I will give the court the citation of the authorities. I concluded before doing that.
So what is it, number one is?
Number one is Republic vs. Geoffrey Mutuku and 4 others. This 2015 EKLR.
2015.
Yes.
Okay.
And we also have Republic vs. Jackson Munene Ndugu. 2020 EKLR. We also have Republic vs. Paul Ndungu Waweru. 2016 EKLR. We also have High Court at Nairobi, criminal case number 57 of 2016. That is Republic versus Frederick Lehman. And 4 others.
Okay.
That's all.
Okay. So are you done? Prosecution side?
Yes, ma'am.
All right. So, Counsel, I think this is a matter which has a lot of anxiety, and you have really submitted a lot. I can see you have been recording 20 pages of typing, so it means quite a lot. I need time to write this ruling here, so we shall take a date for the ruling, whether he is going to be in custody or released. Are we together?
We are together.
So we can have it on the 20th of this month for ruling.
That's convenient, Your Honor.
What do you want him to be detained in the meantime? Capital, yeah. All right, we work on that today for ruling, and I think they've been in custody at Capital Hill Police Station until then.
Your Honor, finally,
yes,
my client is still available for investigation. The days let the police not wait until we come that they say they are, then anybody stop them from investigation. Our client is available to be investigated. No.
All right, then we come back on 20th for ruling.
Much obliged. Much obliged.
Can we have another file?
We have case number 833485. Frida
Your Honor, in that matter,
Yes.
Your Honor, can this person in that matter is absent? You can't come.